Well, good afternoon, everyone, and welcome. I am Deborah Avant, and I'm a professor here at the University of Denver, where I also direct the Joseph Corbell School of International Studies C Center. And I'm pleased to welcome you to this panel on the fight for an open Supreme Court seat. Though she'd been ill for quite some time, the passing of Ruth Bader Ginsburg last Friday seemed sudden. It seemed to many like she would really live forever. And with it became a lot of reflections about her impact for women's rights, for transnational jurisprudence, for the hopes of young girls as she became an icon of leadership exercising different types of power. But not far behind were reflections of what yet another crisis would mean for the future of governance in this country as well as beyond. At University of Denver, several members of this panel, along with about 25 other people, are part of a new knowledge bridge called Navigating the Future of Governance, which we organized to bring together different perspectives and different disciplines to study and reflect on the governance that's growing out of the myriad different crises that we've seen unfold. Though it won't launch until sometime in 2021, this panel is a bit of a prequel. Like the Navigating the Fog, that's the Future of Governance acronym, Knowledge Bridge, it's a collaboration among the Center on American Politics, which, truth be told, did most of the work for this event, the C Center at the Corbell School of International Studies, and the Constitutional Rights and Remedies Program at the Sturm College of Law. Though we focus mostly on the US for this panel, in our larger project will also examine governance experiments in other countries and at the global and local levels. So stay tuned for more on that. Our panel today joins an ongoing stream of events, including a Center on American Politics event that's October 1st at noon, called The Summer of Protest: How Political Activism is Shaping 2020. You can check out the details on the Center on American Politics webpage, and it looks amazing. I hope you can join us for that. So for today's discussion, we are joined first by Sarah Binder, a professor of political science at George Washington University and a senior fellow at the Brookings Institution, who specializes in Congress and legislative politics. She's written many books, including Minority Rights, Majority Rule, and with her husband, who, truth be told, my dog was named after, a book called Stalemate: Causes and Consequences of Legislative Gridlock. She's also an editor of and frequent contributor to the Washington Post's Monkey Cage, and an old and dear friend. So it's super nice to have you with us, Sarah. We also have Josh Wilson, who's a professor in DU's Political Science Department. His work focuses on how conservatives use the court as a political forum, and he's most recently the co-author of Then we have Alan Chen, whose comment on social media last Friday night spurred the idea for this panel. He's a professor at the law school and a leading national expert on free speech doctrine, federal courts, and public interest law. He's the co-author of two books, Public Interest Lawyering and Free Speech Beyond Words. And finally, we have Seth Maskett, who made this all happen. Seth is a professor of political science and director of the Center on American Politics at the University of Denver. He contributes regularly to the 538 and Mischiefs of Faction blogs, and is the author of a new book, Learning from Loss: The Democrats 2016 to 2020, which just came out from Cambridge. And I also want to give special thanks to Aaron Dietrich and Alicia McDowell, who did the setup and logistics for this event. So to begin, I have a question for each of the panelists, and then a long list of follow-ups. Many of them are drawn from your suggestions as you registered. We'll go until about 3, and then reserve about 15 minutes for a Q&A from the questions that you submit during the event. You can submit questions on the Q&A button on your screen. So let me turn first to Sarah to ask you're sitting there in Washington, like, what is going to happen? What are the options for each party, and what are they likely to do?
Sure, great. Well, first, thanks for inviting me, letting me crash the Denver party. This is very, very exciting. So I thought I would just first sort of briefly sketch the procedural lay of the land, and then it will help us think about the party's potential strategies. I think I have two observations here about the procedural context, the rules of the game that are relevant. First, the Democratic minority in the Senate has considerable parliamentary rights in this situation, but they don't necessarily have a lot of power to block the nomination from going through to be confirmed. What does that really mean? There's a number of Senate rules, but there are also committee rules, the Senate Judiciary Committee, that give some procedural advantages to the minority party, but it's sort of hard for the minority to enforce those rights should Republicans decide to disregard them. For example, there are Senate rules that require nominations to go straight to committee for consideration. By practice, the Judiciary Committee will do a background check and conduct public hearings. After a hearing, when the committee majority is ready to vote, any member, including a Democrat in the minority party, can delay the meeting with just a request for up to a week. And when the committee is ready to vote, committee rules require that two members of the minority party make up the quorum of a majority of the committee. So in theory, Democrats have some rules here that they could use to their advantage should they want to delay, or as some have proposed, boycott confirmation hearings. But I would warn that Democrats tried this in early 2019 over an immigration bill, and the chair of the committee, who is still the chair, Lindsey Graham, the senator basically blew right through the rules. There really isn't any way for Democrats to enforce their rights under those rules, which again gives them a little leg up, but not a lot of power in terms of really derailing the nomination. So the Senate floor is potentially a different situation. On the one hand, the Senate works by what we call unanimous consent. The majority leader, Mitch McConnell, wants to say, call off the reading of an amendment. It would take an hour, but I ask unanimous consent. Should we just dispense with the reading? Let's say the rule requires a vote at 1 a.m. He needs unanimous consent to push the votes to say 10 a.m. so senators, can go home to sleep. So Democrats could start blowing up procedural bridges by objecting to these requests for consent. But most elements of the confirmation process really can't be stopped by denying consent. There's no stopping Mitch McConnell when he's ready to go into what we call executive session and call up the nomination for the Supreme Court nominee. Democrats can slow down that executive session with some dilatory motions, but eventually the power is in the hands of the majority party to cut off debate on a Supreme Court nomination and to dismiss dilatory motions. It could be a little messy. It could be dragged out for a little bit, days, maybe a week in the committee, but at the end of the day, a majority is going to rule on Supreme Court nomination. So given the rules of the game, what are the strategies here? What are the options? Well, for the Democrats, there's a lot of push from Democrat activists to blow up bridges. But I think when we're thinking about what are Democrats really going to do, we need to ask ourselves, as they presumably are asking, toward what end? Inconveniencing the majority? Sure, they could do that. Push the vote past November 3rd, election day? Maybe, possibly. But then what? Right? Hope that Mark Kelly wins in Arizona, gets seated early because it's filling John McCain's seat, which is still in existence. Maybe get Collins and maybe Murkowski to vote against cloture, in other words, to derail the nomination. I would say that's a very outside chance. Or is the point, as political scientists call it, socialize the conflict, right? Get the audience off the sidelines and into the fight over the court and what it means for everyday Americans. That seems to be what the minority leader, Chuck Schumer, is saying. He wants to make the point that voters should decide who gets to make the appointment. Most voters, though, have kind of already joined the team, right? And even if Joe Biden were to win the presidency, I'm a little hard pressed to think that even public sentiment would ever shame Mitch McConnell and the Republicans into giving up the chance to put that sixth conservative onto the bench. So Republicans, we know their strategy, even independent of knowing who the nominee is to get this done, I think, presumably before November 3rd, but at least to have the hearings before November 3rd. Democrats seem to be doing a little lighthearted obstruction. They did a little bit yesterday on the floor, but my guess is they're trying to really socialize the conflict, expand the scope of conflict so that more and more people know the stakes at what's at stake here. But it leads me to think that Republicans will seat another conservative onto the bench, if not before November 3rd, then in the week or so afterwards. I'll stop right there.
Great, thanks, Sarah. Okay, my next question goes to Josh. How could this scenario, or sort of different scenarios, if the Democrats do choose to obstruct more, affect the elections?
Great, thanks. And thanks again to organizing and hosting the event. So the elections, there's a few different ways that I think about this in relation to the coming elections. So the first one is, this is definitely, and the major one really, this is about kind of mobilization and enthusiasm for voters. And in another scenario, we might talk a little bit more about undecided voters, swing voters, and so forth being in play for the presidential election. I think of them right now as a bit of a unicorn. It's hard to imagine there being that many voters at this point in time who either aren't dedicated to voting, if they're going to vote or not, or haven't picked who they're going to vote for in the presidential election. So it's basically, if things have already been turned up to 11, right, this is somehow finding room above that level, right? But when I think about it, the other ways I think about this in terms of elections are in terms of there's the presidential election, there are the Senate elections, and then there are elections going into the future. Another little wrinkle that I want to throw in here too is just thinking about elections now across the country as in 2020 is taking place over a longer period of time too, right? Like voting has started in many states. There's been a lot of discussion of vote by mail and so forth. And so instead of it being kind of condensed into one day, right, we have this longer race that's being run. And I see the conflict over what to do about the Supreme Court as kind of just adding some more juice for this longer run, right? It sustains a level of intention or of attention and intensity over the longer period of time of voting. But I said there's a couple of other ways that I want to think about this as well. And the other is in terms of long-term effects. So the Republican base has really understood the importance of courts for a long time, right? This has been a major mobilizing issue, particularly for white evangelicals, for the Christian conservative movement. It's part of really the creating narrative of the modern Christian right, right? So they've been invested in courts for a long time, largely because of Roe versus Wade. Democrats, it's been much less of a priority, hasn't been well understood, hasn't been well internalized, is really the way that I would put it. And I would say that the last 3+ years have been a really intense clinic in educating Democratic voters that elections matter, courts matter, and that elections matter for courts, right? And this is kind of a punctuating moment, like I said, on a 3+ year clinic of these lessons, right? And so I see this current kind of political moment as probably internalizing for Democratic voters how all these things matter and really maybe raising them up in terms of priorities, both in terms of immediate kind of priorities for the party after the 2020 elections, but also priorities for voters and ways for future elections to be kind of structured, or for the language around it to be structured. Lastly, of course, then there's also the Senate races, right? And if the majority of us are here in Colorado, and so we can talk about the Senate race here. And this really pulls it back to focusing on really connecting Cory Gardner to Donald Trump. This makes it a lot harder for Gardner to escape that narrative, right? Especially since he said that he's going to support this nomination, right? And so that allows the discussion of Gardner to be much more focused on look at how Gardner has fallen in line for Trump. And I don't see that really as being a benefit for him in this election. So like I said, there's a lot of different ways to think about it, but that's that gives you some of the terrain that I was thinking of.
Great, thanks, Josh. Now to Alan. I've actually been waiting since Friday night to hear an elaboration of part of his comment was really sort of what, how these different scenarios might affect contestation over the election and future jurisprudence. So if we sort of, have the framework laid out for us about what we might likely expect, what is this going to mean for the future? And let me just add, there's several people that have added Q&As. If you have questions, please ask them and we'll answer them at the end. Alan, please go ahead.
Thanks, and thanks for inviting me to participate in this panel. I just want to take a moment because we're talking about politics and procedures and all the technicalities of the nomination process to celebrate the life of an extraordinary jurist and one of the most amazing public interest lawyers in the history of this country. And this is not a memorial, but I just wanted to acknowledge that since we're, as we move forward and talk about what steps are next. In terms of so the appointment of a replacement for Justice Ginsburg is going to be the cherry on top of a long effort by the conservative legal movement to remake or reinvent the federal court system in ways that they have dreamt about for years. And I think lots of us have thought that that might have happened several years ago. And in fact, the court as it exists today, even with Justice Ginsburg before her death, it's a very, very conservative court in the sort of grand scheme of looking at the ideology of Supreme Courts over the last generation or so. In terms of what the likely fallout is in terms of jurisprudence and contestation of the election, which would obviously just contribute to the chaos of our current political climate. There's a couple things I wanted to talk about. Obviously, the first question that we got before the panel was, would the new justice be able to sit on any case should there be a litigation challenging the outcome of the election, and be seated by then and be able to make a decision in that case? And the short answer to that is yes, unless there was some other conflict of interest or participation by that person as a lawyer in the prior proceedings. There's nothing. Once the justice is sworn in, there's no reason other than that for him or more likely her to recuse themselves. And but I also want to point out that even if this doesn't happen, the conservatives have a 5-3 majority now, right? Justice Ginsburg is gone, and so what would happen if there were a dispute over the election in the lower federal courts in the sort of guise of like Bush versus Gore in 2000? Even if Chief Justice Roberts came over to vote with the liberal wing of the court, that would be a 4-4 split. And the rule there is that if there's a 4-4 split on the US Supreme Court, the lower court decision controls. That is, they can't upset or they can't affirm or reverse the lower court. It just stays as it is. So that means it's going to be important where that case is brought, if there is such a case. I'm hoping there will not be again, but if it were, and that's going to be probably both presidential candidates doing some forum shopping, looking for the circuits where they're most likely to get a favorable draw on of the other federal judges. But that's also problematic because, as I said, the conservative legal movement has said the successful project. President Trump has appointed, I believe, close to 200 federal judges, in addition to 2 Supreme Court justices in his 3.5 or 3 3/4 years in office. So the federal courts are largely composed of a lot of conservative judges as well, which also remains problematic. The other thing I wanted to comment on is that the Supreme Court now is already deciding cases. They're just not deciding fully briefed cases. So all these disputes about challenges to mail-in ballots or that are cropping up in some of the states, when the Republican Party has lost those cases, they've immediately sought emergency relief from the U.S. Supreme Court. This is something that constitutional law scholars call the shadow docket. They're not fully briefed cases, but in an emergency, the Supreme Court can act to stay a lower court decision or to let a lower court decision sort of attach. And I think we're already seeing some of these disputes in the lower federal court. So even before the replacement of Justice Ginsburg, I think the court's going to have a significant amount of influence over the election process and whether some of these restrictions on voting are upheld or struck down. In terms of the longer view about the jurisprudence of the court, obviously lots of people are focusing on Roe versus Wade, which is the Supreme Court is sort of upheld in name, at least, for the past several terms, and whether the new justice would likely be the turning point where Roe versus Wade would be overruled. I think that's fairly likely to happen, even if Justice Roberts voted only with the liberals in the abortion case from Louisiana this term, but he made it clear that he was only voting on it because it was pretty closely matched factually to the decision from a couple of years ago in the whole women's health case. And so I think Roe versus Wade is, I mean, we've been saying this for probably a decade, that Roe versus Wade is nearing its end. If it isn't explicitly overruled, I think it will be so gutted at that point that there will be very little of the right for a woman to choose to have an abortion at least under federal law. And one of the comments I made on social media last Friday was, well, maybe we better start looking at the state Supreme Courts, which can also independently decide that abortion is a right under state constitutions. Currently, there are 13 states plus the District of Columbia where there's an abortion right based on state law. So nothing would change in those states. But the majority of states have restrictions against abortion. There are even several states that have passed laws in the event of the overruling of Roe versus Wade. And those laws are triggered to come into effect immediately upon the overruling of Roe versus Wade. And some of them are complete bans on abortion. Some of them are severe restrictions. But the truth is, restrictions on abortion have been pretty widespread for quite a while now, and they mostly affect poor women, right? So the Supreme Court has allowed states to make it harder to get an abortion, take longer to get an abortion, be more expensive to get an abortion, have abortions only at a particular type of facility that is rare in that particular jurisdiction. So what's left of Roe is already significantly weakened. And so I think progressives ought to be looking to other options in terms of the long-term protection of women's reproductive freedom. There are other areas where the Justice Ginsburg's loss will be significantly seen, obviously in civil rights and gender discrimination in particular. She was a pioneer as a lawyer in developing a theory of that the Constitution not only prohibited overt discrimination against women, but also could be used to strike down laws that perpetuated gender stereotypes. So she was really ahead of her time in terms of trying to use the court as a vehicle to recognize that many of the laws we have, even if they don't at first glance seem to be overtly gender discriminatory, actually are reinforcing gender stereotypes or sex stereotypes and the role and sort of reinforcing the roles of women, the traditional roles of women that are sort of no longer the case. There's several cases on the Supreme Court's docket this term that could be influenced or affected. There's the Obamacare case. The last thread of Obamacare is the pre-existing conditions provision. The Supreme Court is scheduled to hear oral argument in that case a week after the election. There's likely to be, I'm guessing, litigation over the census and the early termination of the census count. That could go up to the court. And of course, that is going to affect the next 10 years of elections because of redistricting after the census. And voting rights, right, which is another area where Justice Ginsburg was incredibly strong force in terms of recognizing that federal law should not be diluted when it comes to protecting the rights of people of color who have been traditionally excluded from the democratic process. So I'll stop there. I could go on for a long time, but I want to let other people talk. So.
Thanks, Alan. Super interesting. So Seth, as one of our participants before said, Seth, save us. I'm not going to ask you to do that. But I am going to ask you, how does the way this is unfolding promise to affect the norms that shape U.S. law and also U.S. politics?
Thanks so much for running this, Debbie. And I don't know who wrote that comment, but I don't think they understand what goes into PhD training. But just to respond about what norms mean in this case. I mean, we hear, a fair number of Democratic politicians right now screaming about like, this is a violation of a norm. And I want to just dig in what that means. So by the end of this year, most likely Donald Trump will have made 3 Supreme Court nominations in his one term in office. And every one of them has involved a significant violation of some norm, and which has resulted really in some of the closest court nomination votes that we've had in history. So of course, Neil Gorsuch was seated after Mitch McConnell refused to consider Obama's nominee. So we had an 8-member court for all of 2016, nearly. Justice Kavanaugh was seated after very serious allegations were raised about his past behavior during the nomination proceedings. Instead of withdrawing the nomination, as previous presidents have done when there's been some sort of scandal raised about the nominee, Trump and Senate Republicans essentially went all in and resulted in virtually a party line vote. And this nomination will violate what McConnell and others said was the rule just 4 years ago, that you don't nominate someone in the last year of a president's term. What does this mean? What does it mean to have a norm violation? Generally a norm violation is something that is perfectly legal and consistent with the Constitution, but it breaks a tradition. On its face, that doesn't sound awful, but it's those norms that really help run the government. That run the Senate and run the court and other things. The Constitution itself is very brief, it's very vague, just a few pages long. It's these norms that have developed over the centuries that are vital for keeping things running. The question is, what do you do when one party repeatedly violates a norm and the other side actually cares about those norms and wanting to protect them? Often what we see in response to a norm violation or a substantial norm violation is that there will be some effort to either pass a very specific rule or a law, making it impossible to do that norm violation again, or to push back with some other norm violations. So we can think, for example, Franklin Roosevelt, when he was president, he broke the norm of running for just 2 terms. He ran for a 3rd and then a 4th term as president. There was nothing in the Constitution that prevented him from doing that, but there had been a norm established since George Washington that you don't do that sort of thing. He did that. After his death, Republicans moved ahead with an amendment making that impossible to do again. Presidents can only serve up to 2 terms now. So, that's one way of approaching a norm violation. And, the other way is to simply, for the other side to essentially push back with its own violations until the two can reach some sort of new equilibrium. We've talked about some of the possible responses in this sense. There could be an attempt for the Senate to establish, the next Senate maybe, to establish more formal rules about when a nominee would receive a vote, or that a nominee would always receive a vote, or something like that. Should Democrats take control of the Senate and the White House, they could decide to simply add more people to the court. They could add 2 or even 3 more justices if they want. That is permissible under the Constitution. There's nothing magic about the number 9 for justices. But again, that is a long-standing norm. So that would be a considerable violation there of that. The Democrats have also floated the idea of adding states. Perhaps granting statehood to the District of Columbia, maybe to Puerto Rico, which would essentially make the Senate somewhat more ideologically balanced, somewhat more representative of the nation's ideology as a whole. There's been additional talk of possible constitutional amendments, maybe creating term limits for justices, which would at least have the benefit of making justices leaving the bench a lot more predictable, and avoiding some of the end of presidency dramas that we've seen. Although at least right now I doubt an amendment to the Constitution is very likely, but we'll see. I think the important thing I want to stress here is that not addressing repeated norm violations is potentially dangerous. That is, if you only have one party following the rules and the other one violating them and not being punished for that, the party that violates the rules a lot will get more of what it wants over time. that can create and build in some imbalances into the system. It can undermine the perceived legitimacy of that democracy. And so generally we see some sort of pushback with these things. I'll end my comments there, but thanks again, Debbie.
All right, thank you. I want to turn back to Sarah for a second, and actually more of you may have some thoughts on this too, is what about these different proposals? You know, last night there were a number of discussions on different news programs about the radical Democratic proposals to pack the court, to unconstitutionally add members, states that don't belong there. And so, like, what are the political implications, I guess, of some of the proposals that have come up on the Democratic side, and how they are being played in this incredibly polarized political situation? So, Sarah, do you want to start, and then we can move to others?
Sure. So it's a great question. I think I would think about it this way. First, whenever especially when it comes to the court and the Senate, whenever people make claims about there's precedent, there's a historical precedent, or there's no precedent, or it's constitutional or it's unconstitutional, those claims tend not to be true. As a starting point, they tend not to be true until we interrogate them and kind of figure it out whether in fact there is precedent. And even if there is precedent, sometimes it is so time-bound not to be irrelevant. So we're going to be always, I think, a little careful when we hear all of these charges back and forth, that more often these proposals reflect the players, not their principles, but the politics of what they're trying to achieve, at least in the short term, their short-term goals. So first is just to be clear that any of these episodes, court expansion has occurred in the past. The admitting of states, that is certainly under Congress's, right? Congress does that by statute. Splitting states, I think, probably needs consent. Right, splitting California to two. I think that, I'll defer to Alan, but I think that requires the state's consent as well as congressional statute. So again, just to, we always want to know whether in fact these claims are true or not. Second, almost all of them, if not all of them, would require, absent any changes in the Senate rules, it would require a supermajority to overcome the debate limitations in the Senate. And of course, this would probably be contingent on unified, probably Democratic control. That is, I don't see a unified Republican government doing this. So if you had a Democratic president and you had a Democratic Senate, one would still need to what we call nuke the remaining type of filibuster that can be used against legislative measures in the Senate. If you wanted to admit Puerto Rico, and Democrats just brought it to the floor, a Republican could be quote unquote filibustered simply by rousing up 41 opponents to even having a vote, or even to call up the measure for consideration. So all of this is really contingent on the electoral outcomes here, and then Democrats really sort of two forks in the road. First, is there a measure that is so important to them, voting rights, statehood, shape of the court, that they're willing to blow up the rules to eliminate the filibuster? So one question is the target. Are they united? And that's the second issue here. In principle, let alone for a particular issue, would there be 50 or 51 Democratic senators willing to blow up the rules? That's not clear, at least judging from history. It's going to depend on the agreement on the policy, will dictate their agreement on the rules. So there's just a lot of uncertainties yet to come. So, and all of it is a possibility, but only if Democrats were to win back control of both.
Yeah, Josh, I saw your little finger go up, and I was actually going to ask you, please comment however you want, but I also wanted to, one of the things that a number of people had asked ahead of time is, you know, kind of the political impacts of the mobilization around this fight in the upcoming election, which obviously will play out for some of the things that Sarah was talking about. So if you want to comment on that as well as whatever you were wanting to say.
No, so the first one, just kind of staying with this idea of proposals that are being floated that kind of Seth covered a bit there. The other thing that I just want to bring up that I think is important to consider here is thinking about the judiciary and Supreme Court as institutions and what gives them power, basically. And so a thing that a lot of people don't kind of think about with the court is, especially in comparison to the other branches of government, is that the judiciary's power is wholly dependent upon the perception of the institution's legitimacy. And so the quick kind of Federalist Papers counterpoints here is, if the executive branch wants to get you to do something, it can physically coerce you to do that, right? They have the power of the sword. If the legislative branch wants to get you to do something, they can coerce you through the power of the purse, right? They can tax you, right? The judiciary, I always say in my classes, the judiciary is somewhat of a disembodied voice. It needs to use its voice to convince others to act on its behalf, be it people in the public or be it actors in the other branches of government. And the way it's able to do that is, by convincing them and through argument and through institutional legitimacy. And one of the things that's protected the court's kind of power and legitimacy over time, in part, is a lot of people just don't think about the courts. But the court also does a lot to project its neutrality, right? Because the perceived neutrality of the court is the core of its claim to being legitimate. That claim to neutrality has really been publicly attacked. I would say, like, a big kind of, in contemporary politics, the big starting point for this, right, is the Bush v. Gore, right? So the turn of this century is the beginning of a really big public discussion of the court as an explicitly political institution. And then that conversation has just been ramped up so much more in the last 4 years, and it's going to get highlighted even more right now. And so I would just put out there that, given that kind of the veil of neutrality that the court has been able to use for decades, centuries really, has been so damaged, that there actually is a good argument here to start talking about, okay, what are other institutional arrangements that we can maybe come up with to try to reassert judicial neutrality, or try to restore kind of faith in the institution. And so I just wanted to kind of insert that in there as a kind of a larger point to think about when Democrats and others are floating different options. The other thing you asked about were kind of mobilizing effects. And so I don't dominate the camera here. Also, I think Seth is actually a really good one to speak to this as well. I don't want to put you on the spot there, Seth, but do you want to take that one?
Yeah, sure. I'll jump in on that. So I get, in terms of like, how much does this mobilize the left versus the right? Is that okay? So yeah, this is interesting. And this is, jumping on Josh, what you were saying earlier about that Supreme Court nominations were generally more of a turnout tool for conservative voters and evangelical Christian voters specifically. That we may have seen a reversal of that in recent years. Polling suggests that the Supreme Court nominations used to be much more of a top issue for Republicans than it was for Democrats. The difference between the parties has really been erased just within the last few years on that. In particular, the Kavanaugh nomination was really, in many ways, highly motivational for voters on both sides, and may have actually, there's some evidence that in 2018 it provided sort of a net turnout boost for Democrats over Republicans. Just to, I hate to work in a tie into my book, but hey, it's the week for that. I had, some of the people I was interviewing for this book, Democratic activists, a number of them talked about the Kavanaugh nomination fight as kind of a radicalizing moment for them. There was one young woman in particular who I'd spoken to who she had jumped in very early as a Joe Biden supporter. She had met him once a long time ago. She was a big believer in him and thought he could win. So she was volunteering for his campaign. And then came the Kavanaugh nomination. And she said she felt that suddenly women's rights and reproductive freedoms and issues about sexual harassment and sexual assault were much more important to her and much more in jeopardy than she realized. And so that motivated her to change teams. She became an Elizabeth Warren supporter after that. And I spoke to a number of activists who had felt similarly coming out of that. And I think particularly with the death of Justice Ginsburg, who really was an icon on the left, one of the most recognizable justices, to the extent a justice can be, a hero of a movement. She really was just kind of a feminist icon and, a real symbol for people on the left. Her loss and her possible replacement by someone much more conservative, I think is sort of, is a potential loss to people and potential, the fear of losing something can be a huge motivator for voter turnout as opposed to, protecting something you already have. So I'll leave it there.
Great, thank you. We actually have a number of questions, Alan, asking a little bit more about what it means to really lose Justice Ginsburg's voice. And, I think that we can think that in policy terms, but also in terms of her relationships. We all know relationships are important on the court and that kind of thing. I wonder if you wanted to talk a little more about that.
Sure, I'd be happy to. So what's interesting about the Supreme Court appointments over the last generation is that, and this goes back to norms again, the Democrats have tended to nominate slightly left of center jurists, right? And nobody sort of extremely far left in the way that I would say many of the current justices are extremely far right. And I think what's interesting about that is that the dynamics on the court, they say that every Supreme Court is different. When you add a new justice, it's a completely different court. And that's because of the relational dynamics that I think these questions are referring to. Justice Ginsburg was probably the second most liberal justice, I would say, after Justice Sotomayor in the current court. And they have sort of bonded together, I think, in the last few years and written some dissents in cases where even Justices Breyer and Justice Kagan sort of voted with the more conservative bloc of the court. And I think the reason that Kagan and Breyer do that sometimes is for the kinds of institutional legitimacy reasons that sometimes compel, I think, Chief Justice Roberts to vote on the more moderate side, or they're saving their voice for other more important issues that they really want to focus on. So, Justice Ginsburg's relationships with other justices across the bench, you saw all the comments from the different justices after her passing. I don't think those are insincere at all, even from the most conservative justices. I think that she was beloved, and they say actually that all the justices get along quite well on a personal level, even if they sharply disagree on politics and in their opinions, and even take sort of little jabs at each other in their written opinions. That as an institution, it gets along, they get along remarkably well. And I think that leads to some, it doesn't lead them to change their ideology, but it does make them listen to each other. And so her ability to influence other justices, both in her camp and on the conservative side in different individual cases, I think is powerful. I mean, I think the same thing that made her an amazing advocate as a lawyer before the Supreme Court made her an amazing justice, turning those persuasive skills around to her colleagues as opposed to presenting them to a court of law. So yeah, and I don't know anything. I don't know a lot about any of the potential nominees in terms of their personal styles, but that dynamic is going to change significantly as well. So yeah, it's going to be a loss. Going back to Josh's point about institutional legitimacy, I think when people see the justices getting along well, I think that's at least I don't think that's just a public face. I think they actually get along quite well, and I think that lends to their legitimacy. We can go to work and argue and yell at each other and write these enormously acerbic opinions about each other's views, and then go to dinner together, which is not what's happening in the other two branches of government. And so at all, I don't think, or I think it used to, but it hasn't in a long time.
Good, thank you. We have a follow-up question actually from somebody about why the court should be neutral. Does somebody want to take that?
I guess since I brought up the idea of neutrality and legitimacy, so the basic idea is, okay, so because that's the role of a judge, right? Is that the reason why people go to institutions, or one of the reasons why people go to institutions to settle their disputes, is because they believe that they'll get treated fairly, right? When I talk about this sometimes I actually was literally talking about this with my students last week, of talking about, it's called the logic of the triad. And this idea of, if you and your sibling have a fight, who do you go to solve that fight? You go to one of your parents. Why do you go to one of your parents? Because we believe that our parents love us equally, right? And so we'll accept the outcome because it's given by a neutral third party, right? But if I believe that the judge is already in the pocket of, or aligned with the interests of my adversary in a dispute, I have no incentive to go to court. And if I go to court, I have no incentive to accept the ruling at the end, right? And so legitimacy rooted in neutrality is really the core of the court's power.
I think I would agree with that. And I would also add that, I mean, you do get surprising decisions from some surprising votes from some justices on some cases. And I don't think you would get that in the Senate or in the House, where partisan politics are more heavily locked in. But having said that, I mean, the court is a political institution. It's just a different kind of political institution. And I think that's something that the American public is maybe starting to recognize, maybe needs to recognize a little bit more. And in terms of how it fits in with the other institutions of the federal government, it's in many ways a dialogical relationship. They talk to each other, they send signals to Congress and to the president and vice versa. And those relationships are important as well. But yeah, of course it's political. It's just not political in the same way.
So one of the questions that someone asked early on when they registered was about a policy proposal we haven't talked about yet, whether we ought to have some kind of requirement that a seat be filled within a certain amount of time to sort of prevent the issue which led Merrick Garland not to be voted on. So I don't know if you have any thoughts on that, any of you, or whether something like that. I mean, part of what we're thinking about, I'm thinking in the context of what Seth was talking about, is to what extent are these proposals likely to actually work, gain some sort of approval, get some kind of buy-in from both sides. And that seems like one that maybe is less fraught than court packing, perhaps, who knows. But anyway, I just didn't know if anybody had any thoughts about that, or whether anybody's even talking about that. Looking at my panelists here.
All right, I'll jump in since I'll let Sarah speak because she knows more about Senate rules than I do. But the only comment I was going to say is, I think there might be a possibility of doing it by Senate rule. If they did it by statute in terms of binding, I'm not sure it would be constitutional.
So I think the issue here, well, it's really twofold. To some extent, not all, but to some extent, the Senate has made progress toward that by eliminating the ability to filibuster Supreme Court nominees. And even though we don't, except for maybe Abe Fortas in the 60s, don't really have evidence that nominations have been blocked by 60 votes, although presidents have withdrawn nominees when they realize, Harriet Miers, someone's not going to get 60 votes. what's the significance of the 60 votes is it was stopping the Senate from coming to an up or down vote, should we confirm or not, right? So the 60 votes is just, are we done, can we cut off debate? So by going to by majority cloture Supreme Court nominations, we have in essence guaranteed a vote, but really it seems only when there's unified party control, right? When the majority party wants to pull up the nominee. And of course, simple majority votes on Supreme Court nominees is a problem that Democrats face right now, which is Republicans would not, again, we don't know the nominee, but we can guess what the nominee would be like. None of the Trump nominees, maybe Gorsuch, maybe would have gotten 60 votes. So to some extent, we've come halfway toward mandatory votes on Supreme Court nominees. But the opposite problem is obviously when it's divided party government, which there is, Mitt Romney, Senator Romney yesterday claimed there's a historical precedent that when it's divided party government in presidential election years, we don't consider it, but that's not historically accurate. So the question is, that's really the harder one, I guess, where the rubber hits the road, as it were. Putting aside the difficulties of writing the rule and enforcing the rule, set that aside, could we ever get both parties to agree that there shall be a vote regardless? And there's some questions about, timing up to an election. Would you put a bar on, let's three months before an election or something like that? It does have the advantage, particularly if it was done, let's say, to take effect and say, it seems like several lifelines away, but say 4 years or even in 2 years, so that at least there'd be some notion of some sort of veil of ignorance, so you don't know whose ox would be gored immediately, who would benefit or would harm. So in general, the movement toward limiting the rights of minority parties and individuals in the Senate, that's where the Senate is heading, and guaranteeing up or down votes, I think that's good for legislatures to come to votes. So in that sense, I could imagine there could be some support for it, but you can imagine the partisan differences depending on whether it's unified or divided control when it would be proposed.
All right. What we have not talked about so far is who this mysterious nominee might be. And I'm not sure if anybody wants to talk. I know Josh has written a little bit about one of the potential nominees. Seth, I'm sure, has thoughts about his nominees. Does anybody want to talk about the potential nominees and whether, it's not just whether they nominate or not, but who that matters?
Yeah, so I can speak a bit about Amy Coney Barrett. So I interviewed her a couple of years ago, actually I think almost to the day, probably 2 years ago, for the co-authored book that I've got coming out. And what's interesting about, there's quite a few things that are interesting about her, but she, in my mind, occupies this convenient space that bridges together different factions within the conservative movement. And so Alan was talking earlier about kind of the conservative legal movement, and it's a common kind of term that is used. We could really, though, divide the conservative legal movement into a secular branch and a religiously motivated branch. And they don't always get along together. And which is why we have these kind of two separate parallel streams with slightly different timelines. But we can find different figures in the conservative legal movement that bridge those divergent streams. And Amy Coney Barrett is one of those people who has appeal on both sides. She's very conservative. She has strong anti-abortion beliefs. And if she does end up being the nominee, I would expect one of the big themes that will be talked about is actually her involvement with the Blackstone Legal Fellowship, which is a conservative Christian legal training program that's part of the Alliance Defending Freedom, which is a conservative Christian public interest legal organization that is basically the motivating organization behind most of the major, for lack of a better term, culture war cases that have come to the US Supreme Court. And so I would imagine that this is going to be, and so this, by the way, shows you part of why she has that strong appeal within the Christian conservative legal movement. And I would fully expect Democrats to really push on that as a reason why she should not be appointed as a Supreme Court justice. But I'll kind of leave it at that as an opening statement about her.
Yeah, Seth,
So, you know, honestly, I don't have much of a background on too many of the potential judges here. You know, I defer to Josh and others on that, but I did want to briefly say who Trump is not likely to pick. You know, some of the names I've seen thrown around are, you know, people like, you know, Judge Judy or Jeanine Pirro or Rudy Giuliani or Ivanka, or, you know, Trump has made a number of unusual hires within the White House and within his cabinet. For the Supreme Court and for other courts, he has generally deferred to some of the organizations that Josh was talking about, to the Federalist Society and others, and tends to pick pretty very conservative, but also conventionally qualified people. This is one of the few areas where he really seems to defer to others within the Republican Party, within the conservative movement, in making hiring decisions and then backing them very strongly.
I know a little bit about Judge Lagoa, who's also been mentioned as a possible, actually a Cuban-American judge from Florida. And she has an interesting background. She's sort of on the fast track. She's been on the 11th Circuit Court of Appeals for, I think, a few months, maybe 8 months. And she was on this Florida Supreme Court for about 8 months before that. Before that, she was an intermediate state court judge. But there are a couple of interesting things about her. One is to the extent that President Trump wants to appeal to a Latino voter base in Florida, that's something that if he views that as, you know, her as being conventionally qualified as well as helping him electorally, I think that's a possibility that could push her to the top of the list. On the other hand, I've already been reading some stuff from conservatives saying, well, she's never really talked about abortion, which she wouldn't likely have talked about as a state court judge. The most noteworthy case she's been involved in is one that I participated in as an amicus recently in the 11th Circuit, which was the case involving the state ballot initiative in Florida to restore voting rights to convicted felons after they've been completed their sentences. And as you might know, this Florida legislature, Republican majority Florida legislature, pushed back and said, well, when it says complete the terms of your sentence, it means you complied with all fines, fees, restitution awards, et cetera, that were part of your sentence. And it's unclear what the amendment is, which was passed by public acclaim, is a little bit ambiguous about exactly what it means. So so some parties brought that to the Florida Supreme Court while Judge Lagoa was on it, and they asked for an advisory opinion saying, what does this language mean? Does it include fees and fines? The Florida Supreme Court said, yes, it means all that. And then the case went to the 11th Circuit, and by that time she was on the 11th Circuit. And it was decided in an en banc decision just a couple of weeks ago, and the 11th Circuit, in a split decision based on who appointed the judges to the bench, also said that yes, that fines and fees are included, which means some upwards of 85,000 people who would have been able to vote are going to be disenfranchised. I bring that up not only because of the substance of the decision, but also there was a strong argument that she should have disqualified herself from the second case, which involved the exact same legal issue, even if not the exact same parties, as the case when she was on the Florida Supreme Court just a few months earlier. So I just wanted to sort of put that out there.
So we have a question that I think follows nicely on that, and I would send it back to Seth, although you guys feel free to chime in if you want to. Otherwise, is there, you know, there's this issue of norm violation, and often the way you see it depends in part on what norms you're paying attention to. So, you know, there are conservatives that are arguing that the Democrats are the ones blowing up norms. So, is there some moral equivalence here? Is there anybody who can, sort of adjudicate between these? I mean, I think about like, is the Lincoln Project, the Never Trumper? I mean, who, at some level, if each side is saying the other is blowing up norms, are we really, is the norms argument where we need to be, or does that bring us to a different place? Seth, you're muted.
Yeah, that is sort of a tricky aspect of the norm violations, in that they are kind of in the eye of the beholder, and frankly, not every norm is good. I mean, Jim Crow used to be a norm, and that was challenged, and for very good reason. But within Senate procedure, it tends to be good to think about it, not just in terms of, is it a norm, but does it lean toward greater democracy? Or does it undermine democracy? Is it consistent with majority rule, or inconsistent with majority rule? And to some extent, you also have just simply, there are people in the room, there are senators in the room that are trying to negotiate these things across parties. And one of the things that could have been an outcome coming out of 2016, if we imagine Hillary Clinton winning the presidency, but Democrats not winning the Senate, there was a decent chance that a Republican Senate would have simply never considered Hillary Clinton's nominee to replace Justice Scalia. And the court would have remained at 8 seats until someone else stepped down, and then it would have gone down to 7 seats or something like that. And we could have seen the other side, then that could flip at a later administration, where you have a Republican administration but a Democratic Senate who refuses to seat that president's judges. That's, on the long run, that's very bad for the court, but it also creates kind of a growing crisis in which the two sides realize they need to work together, regardless of who was right. Regardless of who started it, regardless of what they see as a norm violation, they have to move to that next level. They have to come up with some sort of a new equilibrium where someone can actually end up seated on the court. Right now, we're not in that situation yet, where we're in a situation where you essentially have one party that has been largely putting people on the court for a while now. We'll see if things switch. If there's some attempt by the players to reach sort of a new set of rules, but the system is very much in flux right now.
Yes. Sarah, did you want to weigh in on this? I remember some Twitter activity, I think, around this.
So I guess I would answer it slightly in a slightly different way. Is whenever we're talking about these norms, what we tend to mean is that there's some degree of forbearance, that the players aren't pushing their powers and their procedural rights, at least in the legislative context, as far as they can, that there's some sort of restraint. And to some degree, that helps sort of characterize a lot of the norms that have emerged, particularly on the Senate, over the last half century, that encourage basically cooperation. The norms emerging now seem to be more about conflict, right? I'm not gonna confirm your nominee, but I am gonna confirm this nominee, and so forth. So rather than trying to arbitrate between norms, I guess that I think of it in terms of like degrees of forbearance. Like, what does it get to get? You need both parties to be willing to equally restrain themselves in order certainly for the Senate to work, but also for any organization or any institution, right? So it sort of gets us neither here nor there, but I think thinking of it in those terms perhaps gets us out of the dueling discussion that I try not to be part of, but sometimes get dragged into, of what we call, or some legal scholars call it, asymmetric hardball. Like, which party is more to blame? Which one's more likely to break through the rules? Sometimes that's hard to arbitrate. As I think Seth was suggesting, it's sort of context dependent, right? Which electoral, do you hold the White House? Do you not hold the White House, and so forth? So I think probably there's more norm violation going on by both parties, even though it seems most, from a from recent standpoint, it seems that Republicans have been more likely to play that game. But it really demands both sides' willingness to exercise some degree of restraint and how far they're willing to push their rights.
Can I add one quick thing, which is, so the Republicans sometimes say that the Democrats started it all in the way of a playground fight. It was you started it with the blocking of Robert Bork's nomination by President Reagan, and I think that is a significant turning point. But Judge Bork was also extremely conservative even for that time as a justice. He specifically said he thought that the Supreme Court decision in Griswold versus Connecticut, which held that there's a right of marital couples to use birth control, contraception, that he thought that wrong decision was wrong. There's no right of privacy under the Constitution. So he went in there with, candidly talking about his substantive opinions in ways that were out of step with, I think, even many Republicans at the time. But then since then, I think forbearance is a good way to look at it. I mean, Justice Scalia, I believe, was confirmed 99-1. I think Justice Ginsburg was confirmed 93-7. I mean, you do see these pockets of cooperation, and maybe that has to do with unified party control or something. But there's nothing that requires those senators to vote to confirm those justices. And those just two examples of where there was cooperation, notwithstanding people who might have been viewed as being fairly conservative versus fairly liberal. So.
Yeah, that's super useful. And I mean, I do think, it's interesting. I think forbearance is an important way to think about it. I also think Seth's point about does it lead toward kind of more democracy or less democracy is an important thing too. And of course, both of those issues are absolutely under dispute right now, where, both, you may say one party more than the other, but both parties feel like the issues are so important that winning or a possibility of winning is so much important than cooperating. And then, the extent to which democracy is a good word or not is actually under a bit of dispute in the American polity, which makes me nervous. Although I think I have to underline a point that Seth made, that sometimes these moments when things get awfully bad are the moments when people are creative in finding a way to move forward simply because they are both going to be completely screwed if they don't. I think we're rapidly running out of time, and I want to give the panelists a chance to say something that they want to say. But we also have a lot of questions that are looking really specifically at the issue of adding more seats to the bench on the Supreme Court. And I didn't know if anybody wanted to address some of those specific concerns about whether this is a huge norm violation, whether this is something that may make more sense, the degree to which historically these kinds of things have played out well. Does anybody want to weigh in on that before I give you your last minute?
This is possibly, since nobody else is jumping in, I'll take the risk, but this is getting a bit out of my depth pretty quickly. But the one thing that I would just point to is that if you look at the political institutional development of the judiciary over time, so basically from the Constitution forward, if you looked back at what the federal judiciary looked like, in 1805, it is radically different from what the judiciary looks like today. And then same with the Supreme Court and so forth. But in thinking about these institutional changes, so what I want to do is establish one point is that, yes, the institution has changed dramatically over time in terms of what judges and justices are called on to do, the numbers of courts that there are, the number of judges and justices there are, and so on and so forth. So it's not something that was created, in the beginning there was, and we've had that judiciary ever since. It's definitely an institution that's changed and evolved over time. That said, it's still a massive political lift to change it, right? because we think of it in these terms of this is the way it is and always has been and always should be. So it takes a lot of political force to change those institutions. And this actually throws me back to the last time I remember thinking about something like this was 2000. It was all the rage for a year to talk about abolishing the Electoral College. It's still around, right? And so that shows us something about the kind of the anger, the motivation, the desire to change an institution, but the resilience of the way that institutions are currently constructed.
Right, that's such an important reminder. I was thinking 2016 and abolish the Electoral College and all the sort of movement around that. Does it need? I want to give people a last a chance to say one last thing, and I will go in the order that we started. So, Sarah, do you want to say one last thing?
One last thing, sure. I think I would just leave with the observation that the spread of partisan polarization, both just ideological disagreements between the parties and just sheer partisan team play, we saw it taking root in the 1980s into the 1990s. It permeates the House and Senate. We see it in the behavior of the president. And it is almost remarkable how long it has taken to seep over into Supreme Court confirmation fights. I mean, it has been brewing, obviously, Bork and others, and it's brewed in the lower courts. But now that we're at this point where you actually do have no swing justice, or barely a swing justice in the chief, right? And we have an opposite party, Trump, appointing to replace a liberal. On the one hand, no surprise how combustible this appointment is and will be, but also sort of takes your breath away in terms of the stakes at which we've put the importance on one single person and that court, given the gridlock we see in Congress, that these decisions get bucked up to the courts, and it's Congress's own fault probably of not being able to reach decisions rather than bucking them over. So on that bright note, I'll just stop there.
Thanks, Sarah. Josh.
Okay, I guess my closing note would be to think about why this matters so much to conservatives. And there's 2 points I just want to make. One is kind of backwards looking and the other one's forward looking. The backwards looking one is, we know that this is an institution and a political issue that matters to their base. So they're delivering on kind of electoral promises. But forward looking, we also know that demographic trends do not favor the Republican Party going into the future. And so the judiciary has become the branch where they can create a reservoir of power, where they can basically create an institutional fortress that's insulated from elections to represent their interests if their electoral interests going into the future are more questionable.
Alan.
So just briefly, I wanted to say that I've spent my entire career studying the Supreme Court and believing in the federal court system as an important part of our constitutional democracy. And I think that after this long, I've decided that it is probably not a good thing that we spend so much time, that the Supreme Court has such a significant role. That's not going to go away, and I hope that more people will pay attention to it. But I think in terms of the long-term protection of democracy, I think that we spent far too little time talking about states, state politics, state legislative races, state Supreme Courts, and which are also important vehicles for promoting individual liberty. And I think we have to sort of spread out and sort of start talking about other institutions as well.
Thanks. Seth.
So I wanted to actually return to a question we were addressing a little while ago. Is basically, you know, how neutral should we consider the court? How much is it a political branch of the government? And one of the ways I think about that is our Supreme Court justices politicians. You know, obviously they don't show up at state fairs, they don't kiss babies, they don't do a lot of the things that elected politicians do. And they're also not as visible. You know, I could run into Stephen Breyer at a Starbucks. I'm not sure I would recognize him. And I follow this stuff for a living. But they do have a very political role to play. And it's increasingly a very partisan office. And thinking to Justice Ginsburg, I'm not sure she thought of herself as a politician. And I think of that because she faced some pressure to step down back in 2013, 2014, when Democrats held the White House and the Senate. And I think her argument was, I'm doing a fine job. There's no reason for me to step down right now. I have a lot more work I want to do. Compare that to Justice Anthony Kennedy, who stepped down in 2018, basically thinking about my team, my party needs to continue my work. And if I step down now, I can ensure that transition better. I think he was thinking more like a political figure than she was. I don't know the right way to do this. It's not clear to me what is the right way. I think there are advantages for them to think like politicians, but also making this a more political branch is, in a lot of ways, it undermines some of the institutional legitimacy that we've been talking about here. So it's great that we're wrestling with these issues, but they're kind of big and scary issues to be wrestling with.
Right. They kind of join the queue of the big and scary issues that we're all wrestling with. But I really appreciate Seth for organizing, all of you guys for joining, the audience for being great audience members, all the questions. It was terrific. And we look forward to more discussions. Thank you very much.
Thank you.
Bye, everyone.
Thank you.
All right. Bye, guys.
Okay.
Thank you. It was awesome.
Thanks again.